years ago, a flour mill company in upstate New York decided to get in on a new and growing trend, which was to use human figures, photographs of human figures, in their commercial advertising. And this young lady was named Abigail, and unfortunately she was under the age of legal consent, and she was too young to enter into a contract, and the Franklin Mills Company had not asked her parents for permission, so they sued for her appearing in this advertisement under a relatively new theory of law, the right of privacy. This had been argued in a famous law review article in the Harvard Law Review by Brandeis and Warren in or about 1890, and the New York courts decided, ultimately, the New York Court of Appeals decided that New York State did not recognize a right of privacy as a matter of common law, although the legislature was always free to grant such a right. Believe it or not, after the family lost this case, there was such a thing in those days as public outrage. You don't see it today, but there was public outrage, and as a result, a statute was enacted called the New York Civil Rights Law, sections 50 and 51, which made it not only a misdemeanor, but civilly actionable for the use of someone's photograph or name in a commercial advertisement without written consent. And this statute has been used over the past 100 years. This is not only the 40th anniversary of the Kennedy assassination, it's the 100th anniversary of the New York Civil Rights Law. This statute has been used by such personalities as Johnny Carson, Cary Grant, Christy Brinkley, Woody Allen, Howard Hughes, and many other celebrities to prevent their images from being associated with products that they don't necessarily want to be associated with. And that's the way the state of the law was for about 80 years until 1993, when Random House published the book Case Closed by Gerald Posner. And this print advertising campaign had actually been preceded a couple of weeks earlier by a teaser promising to name the guilty parties in the assassination of President Kennedy. And then a week later, this ad ran in the local and national editions of the New York Times, naming 6 of the critics of the Warren Commission as being guilty of misleading the American public and making the representation that there was only one man, one gun, one inescapable conclusion about the assassination, urging readers to buy and read the book Case Closed. Robert Groton was one of the persons depicted, and he was they attributed a quote to him. I'll read it because you probably can't read it from the screen. Who killed President Kennedy? It took a combination of the CIA-controlled Cuban exiles, organized crime, and the ultra-right wing, with the support of some politically well-connected wealthy men, to pull it off. Well, be that as it may, the problem was that Bob never said this, he never wrote it, and he had always taken the position that we need to find out who killed President Kennedy, and he had focused his work mainly on the photographic and film evidence. In fact, the History Channel seems to be rerunning The Men Who Killed Kennedy this week ad infinitum. You can see the interview that Bob did with them, in which he said, just less than a year before this advertisement, or less than a couple of years before this advertisement appeared, he said, we need to find out. He doesn't know. So this had really been written by Harrison Livingstone, but there was no indication in the advertisement of that fact. And the problem was that Bob was coming out with his own book, competing with Posner's Case Closed, and so this gave a very erroneous impression of the nature of Bob's work and what he had to offer. The genesis of this at Random House is reflected in the following quote from Robert Loomis, who was Gerald Posner's editor. "All the conspiracy theories have undermined the public's belief in government, and that, to me, is a crime." This attitude is still prevalent in many quarters, and I believe it has a great deal to do with why we are still here discussing the case 40 years later. Posner himself had said that he thought the conspiracy theorists have made us lose faith in government. And here's another key point about the entire controversy. I think the debate over evidence in many respects is a false debate. And what we are really talking about, what we are really contending about most of the time, is our value systems and whether we want to uphold blind faith in government or whether we want to uphold the right of the public to question. So we saw some things that were wrong about this ad, not only in terms of the New York Civil Rights Law and the use of the photograph without Bob's permission, but also the misattribution of a conspiracy theory that Mr. Grodin did not sponsor, did not represent. And so we brought suit under not only the New York Civil Rights Law, but also the Federal Lanham Act for making false and misleading representations concerning the nature of Bob's products and services. Not only did he have the book The Killing of a President, that was the title. He also had a companion video, The Case for Conspiracy, which he recently put out on DVD. And I commend that to your attention. These are among the best photographic and film compilations that you'll ever see about this case. And so the Lanham Act had recently been amended in 1989, not only to include false representations about one's own product, but also to make it actionable if you made false representations about someone else's product. And these were the theories that we relied upon. The Second Circuit, which is the Federal Appellate Court in New York, had decided, and this is still good law as far as I know, that there is no measurement of what the impact on the public is concerned when an advertisement is explicitly false. You don't have to take surveys as to how it was understood. It's enough to prove falsity. This same theory had been used in a case in the same court in which Cuisinarts and Robo Coupe were fighting over trademarks and competing advertising representations. And the United States District Court for the Southern District of New York had found this form of advertisement, accusing the other party of misleading the public, to be violative of unfair competition laws. This case occurred before the Lanham Act amendments, but undoubtedly the holding would still apply. Another court, the First Circuit, had found an allegation of blatantly misleading the public sufficiently factual to be proved true or false. So we thought that we were on reasonable grounds. And as far as the First Amendment considerations were concerned, the Second Circuit Court had held previously that movies, plays, and books are, after all, products sold in the marketplace, so some government regulation was warranted. Here in Pennsylvania, there's a famous precedent in the Third Circuit about reference to a public issue in commercial advertising, including negative comparative advertising, does not immunize false and misleading information from government regulation under the Lanham Act. That's the U.S. Healthcare versus Blue Cross of Greater Philadelphia. The defendants argued that the advertisement accurately represented Mr. Posner's book and therefore could not be false and were also protected under the First Amendment. This did not answer the question, what about the attacks, the negative attack against Grodin and the other assassination authors and researchers who were depicted in the ad. Besides which, going back to a Supreme Court case from the 1920s called 95 Barrels of Oil, the courts have construed ads in such a way that even if an advertisement makes a truthful statement about the advertiser's product, if it falsely attacks another person's product, it is false for purposes of unfair competition law. Whoops. So, the defendants brought their customary motion to dismiss, and after all the papers had gone in and all the oral arguments had been had, they brought up a new late argument that the Kennedy assassination is so controversial and seemingly irresolvable that since no one has ascertained with any certainty what happened, the ad must be taken as opinion. And that should sound familiar. We've been hearing that the past week as well. They also said finding a statement of fact in the advertisement would require this court to determine the truth or falsity of the conclusion of the Warren Commission. Well, you have to be familiar with the law of summary judgment, and in particular with a trilogy of cases that the Supreme Court decided in 1986 to understand what was going on here with these arguments. They were raising at the 11th hour the argument that Mr. Groden could not prove the advertising campaign false because he could not prove that the Warren Commission report was false. And that, under the precedents of the Supreme Court dating back to 1986, is enough to trigger a burden upon the plaintiff, in this case, to come forward and say, yes, I can prove the advertisement false. So we responded by letter to the judge saying we offer to prove, through what the government has represented to be the original autopsy x-rays of President Kennedy, that he was assassinated by more than one gunman, so that a jury may decide who is guilty of misleading whom. The defendants were relying upon analogy to libel law, and this is a form of commercial defamation that we were arguing over. The essential point is the statement is not protected if it states or implies assertions of fact which are provable as false. The standard is verifiability, and so is it capable of being objectively characterized as true or false? That's the test. The judge in the case, John S. Martin, Jr., did not respond to our offer to submit a response to the defendant's argument, and instead issued a decision stating that the plaintiff has failed to establish any factual dispute, and we failed to establish any genuine issue. He also stated that the proliferation of theories about the assassination is proof that there is no universally accepted factual answer to the question who killed President Kennedy, and therefore the ad must be interpreted as opinion. Of course, I could go through a whole treatise on the informal fallacies of logic and reasoning and how they apply to this kind of argumentation. Suffice it to say for our purposes today that the issue is not unanimity. The issue is, what is fair and just and what is the truth of the matter. And here again, the judge stated that they rejected the plaintiff's assertion that the ad is capable of objective verification. While this may be true hypothetically, the known evidence concerning the Kennedy assassination and the extensive debate over the Warren Commission's findings demonstrate that the actual facts will never be verifiable to everybody's satisfaction. Bear in mind, he had no evidence in front of him at the time that he wrote this. He also made several references to conspiracy theorists, and referring to the people depicted in the ad. They are all conspiracy theorists of one sort or another. Even William Safire, the language expert of the New York Times, had remarked on the prejudicial character of this kind of epithet. What you do when you call any expressed suspicion, especially a complicated one, a conspiracy theory, you dismiss it as nonsense, the product of an unduly suspicious or even paranoid mind. Well, we did bring a motion to reopen, to reconsider, vacate the judgment. And this time we had, fortunately, with the assistance of Dr. Randy Robertson, who you met yesterday, and Dr. Wecht, and Bob Groden, we addressed the issue of the head wounds and whether President Kennedy had been shot once or twice in the head. I'm going to go over some of that evidence with you now. Just to review for those who are here for the first time today and who have not been following the controversy, the problem is that the autopsy pathologists found an entrance wound in the rear of President Kennedy's head, approximately 2.5 centimeters laterally to the right, and slightly above the external occipital protuberance, which is a bony prominence in the back of the head, just above the fold of the neck. And this was outlined in their autopsy report. And they specified that in the underlying bone, they found a corresponding wound through the skull, which exhibits beveling of the margins of the bone when viewed from the inner aspect of the skull. Now, if you were here yesterday, remember the discussion between Dr. Bodden and Dr. Robertson, which Dr. Bodden insisted that there was, there may be a fracture at that site, but there's no hole. We're going to examine that a little bit more closely right now. And this is a diagram that was made by a fellow by the name of Rydberg, a military artist under Hume's supervision. Notice, if you will, the solid mass of bone between what is purported to be the entrance wound and the larger exit defect here. Roy Kellerman, the Secret Service agent who was driving, who was in the passenger side of the front seat of the limousine at the time of the assassination and who attended the autopsy that night, testified before our inspector that there was a space of about 2 inches here of bone between the entrance wound and the exit defect, and this diagram has it about right. Also, during the House committee proceedings, all 3 of the autopsy pathologists marked a skull at the location where they said the entrance defect was, and of course it agreed with their autopsy report. It disagreed with the Clark panel and with the majority of the forensic pathology panel for the HSCA. Here's a drawing that was done for the staff of the HSCA by Richard Lipsey, who was present at the autopsy, and this shows, as you can see, maybe I can point that out to you, and maybe not. I understand that this dot shows up very light in the back, but you can see that Mr. Lipsey has made a mark on the rear of the skull which conforms to the location for the entrance wound in the head that was given by the autopsy pathologists. However, in 1968, Ramsey Clark appointed a panel of very prominent physicians to examine the autopsy x-rays and photographs in the archives. Actually, I believe that, yes, they were appointed in 68. The report was not issued until January of 69. They found that the autopsy pathologists had been mistaken and that there was the entrance hole was actually 100 millimeters, 10 centimeters, 4 inches above the wound alleged in the EOP. So what we had was either a migrating wound or a second wound. Either the autopsy pathologists were mistaken or both sets of doctors were correct. This diagram, which was done by Ida Dox for the HSCA, shows basically the Clark panel version of the head wound, with which the majority of the FPP agreed. And you will notice that this diagram does not portray the transverse fracture that Dr. Robertson pointed out to you yesterday at the site where Drs. Humes, Boswell, and Fink placed the entrance wound.
Here's a drawing that Dr. Humes made, presumably without the help of the photographs or x-rays, but I'd like to point out that this is another wound slightly above the EOP, and there is bone intervening between it and the large defect at the top of the skull. The HSCA incorporates the entry hole at the edge of the large defect. Here again is another one. This is on the skin surface, but entry hole slightly above the EOP with bone or intervening between it and the large defect at the top rear, well, at the rear of the, on the right side of the head, excuse me. Here's a skull that was marked by them for the forensic pathology panel. Just remember that this is 15 years after the assassination. 3 different people marked this skull, and there is tremendous unanimity about where this bullet entered. Not up here, down here. And remember, these were the fellows who had the skull in their hands.
Dr. Bodden says there was no hole where Humes, Boswell, and Fink said there was. How do we know? How can we be confident that there was? First of all, there was internal beveling. This was noted by all three pathologists, but recall that Dr. Fink arrived late in the proceeding, late in the evening, after the brain had been removed. The removal of the brain necessitated the removal of bone at the site of the vertex where the HSCA panel said the entrance wound was, and yet Dr. Fink described in detail his examination of internal beveling at the site of the entrance wound in the skull. He could not have been talking about the higher wound referred to by the Clark panel and the HSCA panel because the bone and the brain in that area had already been removed by the time he arrived. And so these three doctors, Humes is now deceased, but all three of them, whenever questioned about this, agreed as to the location of the internal beveling that they examined. We also had witnesses, as I showed you, Roy Kellerman, Richard Lipsey, and the drawing that was done by Rydberg at the behest of Humes, which further corroborates the location. Dr. Bodden also has argued that because the cerebellum was intact, the wound could not have been at the lower location identified by Humes, Boswell, and Fink. We can answer this by resort to an MRI, and I'll come back to these. This is an MRI that was made by Dr. Robertson, and it shows that the bullet, if it behaved as Humes, Boswell, and Fink had it, would have entered 2 centimeters above the cerebellum, and the distance would have increased as the bullet transversed the skull. So both of these arguments must fail in light of what the evidence actually shows.
When I looked at these films, I was looking at this drawing and I said, in all the meticulous detail, they forgot a fracture down here, right here, which just happens to be at the level that the autopsy doctor said a bullet entered. Not one radiologist who has examined these x-rays for the government has ever mentioned this fracture. And I would like to point out that this just isn't any fracture. I didn't pick a fracture up here or a fracture down there, whatever. Fracture right here, right where the autopsy doctors said a bullet entered. If you read carefully, as I have done through many of the eyewitness testimony, our inspector was questioning Roy Kellerman, a Secret Service agent, who was an eyewitness to the autopsy, and he asked him, what was the distance which separated the large hole at the vertex with the small hole of entry? Roy Kellerman indicated a distance of 2 inches. This is exactly the amount of bone which intervenes between the transverse fracture and the impact point at this higher thing. I don't think Roy Kellerman was hallucinating what he saw. It fits the x-rays and photographs exactly.
Courtesy of the Iraq War, these photographs illustrate for us Puppa's rule, which is that where the skull has been fractured by one impact and then another, the fractures propagated by the second injury will stop where they intersect with the pre-existing fracture lines caused by the first injury. And this can be illustrated, in this case, by bullet holes in a windshield. This is where you see the arrow on the lower left-hand corner of the screen. That is the transverse fracture at the site of the Humes, Boswell, and Fink entry wound as identified by Dr. Robertson, and this fracture has never been mentioned by any of the examiners going back to the original inventorying of the materials by Humes, Boswell, and Fink in January of 1967. What you see, if I can point this out, that white circle there is the site of what was identified by the Clark panel and the HSCA as a roughly 6.5 millimeter round metallic fragment. This was seen the night of the autopsy on the x-rays by Edward Reed, one of the technicians present in the morgue. And then we have the fractures radiating down from that site, which is basically what the Clark and HSCA panels have identified as the site of their wound. We have the fractures radiating down and intersecting with the transverse fracture. And notice something very interesting. This is a detail from a diagram that was drawn by J. Thornton Boswell, one of the pathologists, on the night of the autopsy. It's on the reverse side of his face sheet, and it identifies the 3-4-6 triangular fragment of bone that we see delineated by the fracture pattern that was identified by Dr. Robertson. This is the lateral skull x-ray that was published. There is one that has never been published and remains in the archives. Again, the arrow on the left side of your screen shows the site of the fracture, and Dr. Robertson has said that it is certainly wide enough to accommodate a bullet. Interestingly, you have the so-called cloud of fragments here. We don't see any metallic fragmentation at this site, which tells us that the bullet that entered there did not fragment until it exited the skull. By the way, just as an aside, this is a controversial photograph which has been called Fox number 8 by the researchers, and you see this semicircular defect which the majority of the HSCA's forensic pathology panel decided was the exit point for the bullet that entered the rear of the skull. I must say it's obvious to me. I don't know about you, and I fail to see how anyone could have failed to notice it at the bench, although there was never any mention made of it by any of the autopsy pathologists.
Now, there is a principle called Puppe's phenomenon, P-U-P-P-E'-S, that states that pre-existing fractures will stop the propagation of secondary fractures, and I think Roger Feinman demonstrated that yesterday, by the pre-existing gap in the bone. And if we look here at this impact point, a fracture extends across the midline, and it's interrupted by this fracture, which is continuation of the fracture of the right occipital bone. And in my opinion, this fracture stops at, here's the transverse fracture here, and here's its continuation up this way. And I believe it stopped at this point. So that means that this fracture was the first fracture created in the skull, this manifest Puppe's phenomenon. It authenticates or it validates the autopsy doctor's location of an initial wound of entrance low in the rear of the head. At this point, there's a small area which would appear to be a violation of Puppe's phenomenon. This fracture here is actually a fracture of the zygomatic arch and inferior orbital rim on the right. And by the way, this is switched now because in radiology we put the right side on the left and the left side on the right when looking at the patients. And this is a blow-up of it. Now, this is not the best one, but in my estimation, the edges of this fracture here, which are in the occipital area, are sharply defined. This one here is fuzzier, and the direction of propagation of this fracture does not line up with this fracture. So it's my opinion that Puppe's phenomenon still exists. If I wanted to play games, I could say, well, geez, that's where the bullet entered, and that's just a fracture created by the first bullet's entry. I really can't see a bullet hole. I wish I could, but I can say that the fracture down low manifests Puppe's phenomenon and means it was a primary fracture created by the first bullet. Where exactly along that fracture line the bullet entered, I don't know. But Puppe's phenomenon says that that fracture was created first, and a bullet had to have entered at that level initially. The second bullet struck up high, causing radiating fractures, which isolated and finally freed the top rear of the skull, which we've seen was ejected onto the trunk of the limousine only after the ITEC study shows a second force being applied to the head.
Now, here we get into something very interesting I want you to watch very carefully. This is frame 312. This is the moment in the Zapruder film where most people, critics and defenders of the Warren Report alike, seem to agree that the first headshot, that a shot did strike President Kennedy's head. We move to frame 313, and we have this terrible explosion on the right temporoparietal fronto region of the head. 314, what I want to point out to you here is that the top and the back of President Kennedy's head is still neatly combed and in place. You're going to see this on the filmic rendition of this in just a moment. But I just want to show you the stills to call your attention to this. And then here's 315. Now we see a disturbance on the top and back. The hair becomes a little bit more disheveled. And that continues to 316. Let me run that by you in very rapid succession, and then we'll take a look at the film. Okay, these are exhibits that were submitted to the court in the Groton versus Random House case as part. That's 313. Now we have 314. Notice the top and back of his head is still neatly combed and in place, and it changes at 315. This, by the way, is a slightly more precise rendition of the theory that was popularized by Josiah Tink Thompson in 6 Seconds in Dallas, the double headshot. It's 312 to 313. Then we go 313 to 314. Now you see the disturbance clearly on the top and back of President Kennedy's head. Dr. George McConnell, one of the radiological consultants to the House Select Committee on Assassinations, noted that there was an elevation of the galea at the site of this, the higher wound, which is, or it can be, not necessarily, but it can be characteristic of a wound of entry in gunshot cases. Okay. The problem is this. Here is an autopsy photograph that was taken from the head of the table with the president lying in the supine position. We see this terrible damage to the right parietal region. We do not see that in frames 313 or 314. We don't even get a hint of it until Zapruder frames 315 and 316. So there must have been some separate mechanism to cause this damage to President Kennedy's head, and my contention is the man was shot twice in the head, and there just can't be any serious question about it. Dr. Wecht went to the archives with Dr. Robertson and agreed that the fracture, the transverse fracture, seems to be consistent with a bullet entry, and where the original autopsy pathologist stated it was. This was very difficult. It was difficult for me to ask him to do this, and I'm sure it was difficult for him to do because he had previously taken the public position that President Kennedy, the medical evidence supported only one shot to the rear of the skull. And Dr. Wecht's opinion, by the way, is contingent upon the authenticity of this photograph of the back of the head. This is a controversial photograph. If it is genuine, then it shows an entry wound at the vertex, and it also shows the location where Humes, Boswell, and Fink identified. If this is authentic, the man was shot twice from behind. If there's a problem with this photograph, it's possible. And I'm agnostic on the directionality. I don't even think the directionality of the second shot is important. It's enough that there's physical evidence of a second shot to the head. Needless to say, Judge Martin wasn't very interested in looking at our evidence and stated that we had produced nothing new, and so we were consigned to an appeal to the United States Court of Appeals for the Second Circuit, the chief judge of which at the time was Earl Warren's former senior law clerk, who reserved this case to himself as head of the appellate panel. And his take on the case was that Mr. Groton had ample opportunity to present evidence outside the pleadings, and but that we had failed to present facts supporting the claim of false advertising. And despite the fact that we had actually objected to expanding this lawsuit to include the assassination controversy, Newman also said that Groden's real interest in filing this suit was an attempt to use the courts as a forum for ascertaining the facts, as if, not that there's anything wrong with that, but as if it's some great abuse of the judicial process. I want to also mention something about Mark Lane, who also brought a suit because his photograph was used in the same advertising campaign. He brought suit down in the district court for the District of Columbia. I did not represent him. He was represented by a very fine attorney who had once served as a law clerk to Judge Henry Friendly of the late Henry Friendly of the Second Circuit. And here's what Lamberth had to say about Mark. Random House, in publicizing its own book, has publicized Lane's as well, so they did him a favor by attacking him in this ad. And he called it a comparatively bland charge and a constrained chastisement. It's quite simply untenable that someone espousing Lane's views would take umbrage at the rather reserved assessment that he misled the American public. This is the federal courts. Under Lane's lopsided rules of engagement, he gets his choice of weaponry and tactics. Random House must do battle unarmed and march openly in a straight line. Well, I've never seen. I have seen judges attack litigants before, but considering Mr. Lane's longtime membership in the bar, his standing in the community, I have not seen a litigant attacked like this in a very long while. If Judge Lamberth's solution was, if Lane is offended by this kind of advertisement, he may elect to minimize his exposure by opting for a lower public profile. This is a photograph of the attorney on your left who represented Random House and the New York Times and Mr. Posner in this litigation. The woman on the right is Judge Judith Kaye, the Chief Judge of the State of New York and the Chief Judge, of course, of the New York Court of Appeals. Judge Kaye is presenting my adversary with the John J. McCloy Memorial Award. So, look, after 40 years, what do you expect? I have to say, I have to tell you that as a result of my criticizing Judge Martin for his decision and trying to disqualify him, I was disbarred from the practice of law in New York. I state this not to appeal to your sympathy, but as a cautionary tale. This is what it means to stand toe-to-toe, even 40 years later, with people who regard criticism of the Warren Report and the continued investigation of this case as a threat to public tranquility, as a threat to respect for public officials and public institutions. It's dangerous work. And all I can say is mostly especially to the younger people in the audience, never give in. Dr. King taught us that the arc of the moral universe is long, but it bends towards justice. Never give in. Bobby Kennedy warned us. Justice delayed is democracy denied. Never give in. For it is written in the book of Job, there is no darkness nor shadow of death where the workers of iniquity can hide themselves. And the prophet Isaiah tells us, he giveth power to the faint, and to them that have no might he increaseth strength. Never give in until the truth is known, until justice is done. God bless us all. Thank you very much.
Although I'm certain that it will do nothing to discourage the conspiracy peddlers, there is no evidence of a conspiracy in the assassination of George Hammond. Those are our findings. The evidence will be available to you as soon as possible. Thank you. This is an announcement, gentlemen. There will be no questions.